In our last video, where we were talking about liens and slavery under the straw man name, the all caps name, we stopped on this issue. I had mentioned that I'd been hearing an unrebutted affidavit stands as truth. What most people don't tell you is that most attorneys will not respond to an affidavit. So whenever you file a complaint, whenever you do the instrument lien process, you always want to include an affidavit. Now, as I mentioned, I've been hearing that an unrebutted affidavit stands as truth. I know now, because I've spent the last hour and a half doing research on it, that an unrebutted affidavit stands as truth. I have proof now. So what I will do is I will provide you that proof. This law here, it says the Court of Appeal may not assume truth of allegations in a pleading which are contradicted by affidavit. Okay, so that can kind of lead a person to say, well, that's your proof right there, but that's not the proof. Here is the proof. We have here, well, let me explain what I had to do. I had to take that statement and I had to continue with that statement that an unrebutted affidavit stands as truth. So here is a court case with a gentleman named Poole. And it says his claim is sufficient pleading to satisfy the pleading requirement of Rule 32. This is obviously an Arizona case. It says, and his factual allegations were unrefuted by the state. Therefore, they must be accepted as truth. And then it mentions base versus the state. And this was done in 1992. When the state does not respond to a petitioner's allegation, the unrefuted statement of facts must be taken as truth. And then it lists Smith versus State in 1991. In addition, his claim is not precluded by any of the provisions of the rule. Because his claim is not barred, is sufficiently pled, and is unrefuted by the state, Poole is entitled for an opportunity to prove his claim. In other words, they couldn't dismiss this case, and I guarantee you, if you go back and look at this case in the original court, you will find that the very first thing the prosecution did is ask for a motion to dismiss. The judge went along with it. He appealed it. The appeal court reversed that decision. Why? Because not only did he have an affidavit, but he alleged the affidavit fact that it had not been refuted. And an unrefuted affidavit stands as truth in law. It's a maxim. I just needed to find the maxim, and so you have three cases here: the Poole case, the Bates case, and the Smith case. Now, let me explain why this was important, why I needed to do this. Every last one of my complaints that have been filed, the last 10, I always include the word affidavit. There is always an affidavit attached to the complaint, or I make the affidavit part of the complaint. Why? Because the affidavit stands as truth. I knew the maxim, just never knew where to find it. So here are three cases showing that. None of the attorneys have ever responded to a single affidavit in a single case. However, in the UPS case that I continue to mention to all of you, the attorney provided an affidavit from someone who had no knowledge of the case. This is just somebody who works for UPS who is aware of its tariffs and rules, but he had nothing to do with the case. I responded to that affidavit and I refuted every single point by point, line by line. Why? Because an affidavit must be refuted point by point. You'll see that in a minute. Now, this is one case, and to let you know, I did a Google search on unrefuted affidavit, but because I'm not online anymore, this is the Court of Criminal Appeals of Alabama, and this is Poole versus State. And again, this was the final decision of March 2007, but as you saw the date of the case, it was earlier than that. Well, no, the Bates and Smith case was 1991, 1992. So this is the Poole case, 2007. So apparently this pro se litigant did his research. So his name is David Lawrence Poole, and he appeals to the circuit court and summary denial of his Rule 32. So basically he filed a petition. When you sign a plea agreement in the state of Arizona or Alabama or any other state, and it's a federal Rule 32, that you are allowed to ask for post-conviction, after you've been convicted because you signed a plea agreement, relief. Well, Poole asked for post-conviction relief and they denied his claim. The only problem is he did an affidavit with it. And because of him doing an affidavit, it couldn't be summarily denied if the affidavit wasn't refuted. There are some other issues that they mentioned, that he sufficiently pled his case. In other words, he listed all the pertinent issues. In other words, he gave the right of claim, who he was, who the defendants was. He gave the who, what, when, where, and hows. And because he did that, his case was remanded back to the state court. So the court summarily denial of his Rule number 32, and that was the circuit court. I guess the circuit court is like a superior court or a district court or state district court. But it lets us know, and see, it has nothing to do with what he was originally charged for, but because he's doing an appeal of that original charge, then that's what he was appealing. If you are doing a civil case like we are, you will appeal all of the missteps. The fact that you asked for a common law trial, the fact that you made the court aware that you were reserving all of your rights, and so on and so forth. This video will be a lot smaller than the other videos. This is just an update. Okay, the next case is Sharon Hayes, and she was representing her deceased husband, and she was handling the estate of Howard Hayes. Now she's the plaintiff and the appellant because even she had a problem with her case, where her case was denied. Her case was dismissed. Now they go ahead and they explain why the case was dismissed and everything, and give me a second. I'm hoping it'll let me refresh because I'm not on the internet, so it may or may not. These are just pages that I've saved, and I'm trying to, as a matter of fact, let's do it an easier way. Instead of me looking for the sections, let me go ahead and pull up the sections. Note, we're going to talk about the first case. We'll come back to Mrs. Hayes in a minute, but we're going to talk about the first case that I took a look at, and this is Avery. Forgot the full name of this case, but I do know that the defendant's name was Avery. It says, additionally, Avery's claim that the trial court was without jurisdiction to render the judgment or to impose sentence because he said, although he was indicted for burglary in the 3rd degree, he pled guilty to and was convicted of burglary in the 2nd degree, which means that without an indictment, and you're going to see that that's what the court ruled. It says he attached a copy of his indictment showing that the indictment was for burglary in the 3rd degree, so he gave evidence, and a copy of an Ireland form indicating that Avery had pled guilty to burglary in the 2nd degree. The state's response to Avery's petition did not address the merits of Avery's jurisdictional claim. Therefore, Avery's unrefuted claim must be accepted as truth. And then it lists Bates versus State, 1992. And again, Bates is going to list Smith versus State, 1991. Now it says if the defendant, and this is still Avery, pleads guilty to an offense for which he has not been indicted, the trial court does not have jurisdiction to render judgment on a guilty plea. So when you raise jurisdiction and you do it on the onset, if the trial court has no jurisdiction, none of the rulings stand. In each of my cases, jurisdiction has been the issue, and the judge repeatedly refuses to bring up on the record what the jurisdiction is. So as I stated before, because I filed under jurisdiction of common law, I'm going to continue under that jurisdiction until another jurisdiction is stated on the record, because the jurisdiction of common law is on the record, the original filing. Doesn't matter how they changed the name. Doesn't matter how they changed the caption. They did so without doing it on the record, and thus it can't stand. Okay, getting back to, now here we go to the Pools claim. That's what we just read. Okay, so that was that case, and as you see, everything that was in that case is here. Now, let's see. I'm hoping it will let me. Let's do a back and a back. Okay, let's do this particular claim. Like I said, I'm working with this software, but this software I kind of like. So I'll eventually adjust my accelerator, my video accelerator, and then I won't have the problem. I believe you're able to see the screen clearly, but when I'm looking at the screen, the words bunch up together because of the accelerator, and the program tells me that it doesn't work well with accelerators. But Dury played this claim in his petition with sufficient specificity, to satisfy the pleading requirements in Rule 32 and Rule 32-6b, and the state did not refute this claim in its response to Dury's petition. Therefore, Dury's claim must be accepted as truth. Then it lists base versus state. Now notice, when the state does not respond to a petitioner's allegations, the unrefuted statement of fact must be taken as truth. Then he quotes Smith versus State. Because Dury's claim that he was not afforded probation revocation hearings, a probation revocation hearing is jurisdictional, is sufficiently pled, and went too far. And was present evidence in order to satisfy the burden of proof. We believe the defendant's unrebutted affidavit meets the burden established that James, as a member of defendant's control group, the facts alleged in James' deposition and affidavit were not present evidence in order to satisfy the burden of proof. Again, we're dealing with unrebutted affidavit and how they stand as true. And that's the issue here. We believe that the defendant's unrebutted affidavit meets the burden established in James, members of the defendants. I just read that, so I apologize. It says James' disposition and affidavit declared that he was the sole director of claims of personal injury. And let's see, I think it's up here. The facts alleged in James' deposition were not challenged. You see, an unrebutted affidavit stands as truth. Why? Because it's unrebutted. Nobody can come and say, that's not true later, because it's unrebutted. They can't rebut it later. It's that acquiescing. You see, a person has to be given an opportunity to answer, stand, or acquiesce. And for the most part, most people acquiesce. Let me see if I have that law, if my website is still here. And I'll know in just a second. That's not my site. Nope. Well, maybe. Maybe I might be able to pull it up. If it lets me go to it. Because it shouldn't be. I'm hoping that it'll let me pull it up because it will refresh in the catch, because I haven't cleared the catch. So if it pulls up, I'll be able to show you where it explicitly says that an individual will be given an opportunity to answer, acquiesce, or not respond. Now, here's the next one. The plaintiff refutes none of these facts. We accept them as true because they don't refute it. Unrefuted facts accepted as true for the purposes of appeal. It's a maxim in law. And again, I knew it was a maxim, but I had to prove it. because I can't just take everybody on the internet's word that it's a maxim at law. I need to prove that it's a maxim. And so that's what I'm doing here with this particular issue. Is I must prove that that's exactly what's going on here. Now, we have this case. Now, these two cases, this is one case right here. I just wasn't able to pull up everything. But the Hayes case pretty much says the same things as those do. Now, we're going to go to the red section. The court must treat all unrefuted allegations as true. And this is C. Stankel versus the state in 2005. When no evidentiary hearing is held on a motion for post-conviction relief, a movant's allegations are accepted as true unless they are conclusively refuted by the record. So it has to be refuted, and when nobody refutes it, it stands as truth. So when the defense attorney wants to ask for summary judgment and wants to ask that your case be dismissed, there are issues still outstanding because he didn't refute it. So if you bring up allegations that they don't refute, that stands as truth. So do not be afraid of summary judgment, because summary judgment now has to be in your favor, because there are allegations that are made that are no longer allegation. They stand as truth. And remember, the allegations must be facially sufficient to claim for relief and is not refuted by the record. It has to be refuted on the record. So there has to be a record of it. It can't be, oh, well, Your Honor, we're going to refute it today because we just found out about it. No, they know about this. These are laws that they know about. You see, the most recent case is 2007, 2005. They know. Now, it says, while Gassner did not offer any evidence to the contrary, based on this, the court concluded that RMC's evidence gives unrefuted and must be accepted as true, leaving no issue of fact. So this was a particular defendant who decided that he wasn't going, well, he didn't know that he had to respond. So this is the issue. Most people don't know. If you receive a letter from a creditor, if you receive a letter from a government agency, if you receive a letter from anyone claiming that you did this, you did that, you owe this, you owe that, you must respond. Even if you can say, I have no idea what you're talking about. I am not the person for whom you're referring. Could you please supply me with some evidence, some proof, something? You see, you have to respond. When you don't respond, you fall under that maxim. Whatever they're claiming becomes true because you failed to respond. So, what we have done here today, and I'm sorry, I just hit close, and I know it's going to ask me if I want to save. No, it didn't. This is what I was trying to pull up. So it did pull up the page because it saved it in a catch. I am going to look to see. There is another law that says a man must be given an opportunity to acquiesce, and I don't know if that's on the site. So, and again, this is the site, but this is not the site. This is just information on the site. So let's see if I added it to one of the documents. And I'm not going to place you on pause. I'm not going to take all day either. But what I will do, this is one of the documents on the website. So what I will do is I will see if I can find that particular case law real quick, which shows that when you're placing a lien on someone's property, that they have to be given an opportunity to respond or to acquiesce. That's the law. So you must give them an opportunity to respond. And I have that law, but it may not be on this page. and I'm sorry, but I thought it was up at the top and it's not. So I didn't think to set it to the side. So I guess I will place you on pause for a brief moment while I look for that. What we mentioned to you in the past was we don't do any advertisement. The only thing you'll hear us say is thank you for visiting us at the Legal Redress Commission, redressright.youtube channel, or Redress Right YouTube channel. That's the only advertisement you will hear from us. That's the only advertisement you will see from us. There's no advertisement whatsoever on our site. As of December of 2006, without advertising, we were having 1,100 people visit our site. Now these 1,100, as it said, we do not advertise. We will keep that as our motto. We rely on word of mouth. If people are interested in this information, we feel that they will find it. Now, when you want to do a search, what I did is I did a Google search on the term Affidavit of Truth. See, unrefuted claim must be accepted as true, and then I said case law. But this is not the one. Yeah, I think that is the wording that I had. Unrefuted claim must be accepted as truth. And so these are the cases that came up. The Gassner case, the Dennis case, Dennis Weaver case. And when those cases came up, I looked for that phrase. Okay, because the phrase was the important part. I could care less about the case. So let's see if I can show that phrase to you. It says must be accepted as truth. And so I go to the case and I look for that statement. And now I find the words unrefuted must be accepted as truth. And when I find that, I apply that to my cases. Let's see, what site was this? Oh, okay, yes. This is one of the sites that got us started on what we're doing right now. And for me, that's what I needed. Now, remember how I told you we always affix an affidavit to our complaints? Well, as you see, there is a commercial or instrument affidavit. And then we do a verified complaint, because a verified complaint is an attested statement. It's verified with your signature as true. Now, what I need to do is I need to go to this. I don't need the commercial affidavit. I need to actually go to this page of the verified complaint so that I can see if that case law is there, because I said when I took us off that I was going to go to that particular case law, and I didn't, so I apologize for that. But I'm going to see if I can go there now, if it will let me. And no, it's not letting me. So it's not going to let me go there. Let's see if it lets me go to the uccidiots.tripod.com. No, it didn't even let me go there. And I haven't maintained the UCC Idiots part of the site in quite some time. So, as you see, it didn't let me go there. So, I'll have to check out that part of the site to make sure it's running like it should. So that particular law I'm not able to find. I will do this one last time. I'll place you on hold briefly. That took about 20 minutes to find this document. But I needed the case law. That was the important part. Notice what the case law says. It says due process requires. Sorry, that was my fault. And now I need to undo that. Due process requires at a minimum that an individual be given a meaningful opportunity to be heard prior to being subjected by force of law to any significant deprivation. That the hearing required by due process is subject to waiver and is not fixed in form, does not affect its root requirement that an individual be given an opportunity for a hearing before he is deprived of any significant property interests. Now, that's the issue. When you're doing the instrument lien process, an individual must be given an opportunity to respond, and that's Randon versus the appellate department. Now notice the other case that supports it. In the latter case, Moline versus Central Hanover Trust Company, we said that the right to be heard has little reality or worth unless one is informed that the matter is pending and can choose for himself whether to appear or default, acquiesce, or contest. Now, here is the problem. UPS chose to ignore, chose to default, chose to be in dishonor. And the law says that due process requires that they be given the opportunity. They were given the opportunity because an affidavit was included with the commercial lien process at the time. They cannot come back and say, well, Your Honor, we're refuting this, we're rejecting to that. They cannot. It's too late. They were given an opportunity and it complied with the law. So, when it comes to an unrefuted affidavit standing as truth, you now have the case law to prove it. You now know that with all of your documents, when you start the process, you always want to include an affidavit stating the facts. You don't state conclusions of law. So, when you get a chance, and this is definitely when you get a chance, this is the site, well, this is one of the forms that I had on my computer that I had to search for to pull that up for you. Let's see if I can find that site again. Could it be here? Nope, it's not there. It's not there. And it's here. On the last video, I told you that it was the notary default process. It's not the notary default process, and they are pleading with you not to use this phrase when you do the, let's switch pages so that I can see what you see, notary certificate of default method. You do not want to use notary protest method. You do not want to use the words notary protest method. You see, notary protest method, you don't want to use that phrase. And this page explains that. Now, here's the notary certificate of default method. You see, like we changed it from commercial lien to instrument lien. Why? Because it's a commercial instrument. So why not? You can even do commercial instrument lien, just not commercial lien by itself. And please read what it says about the notary. Some of you people will not care what happens to the notary, but when you do that, you prevent yourself from using the process later, and you prevent others from being able to utilize the process. I had my documents notarized, but I sent everything certified mail. It explains why you want to send it through the notary. Now, here is the section that explains to you, and I shouldn't be doing that. Give me one momento. Here is the section that explains to you why you don't want to put the notary in that type of a bind. Okay? But it also will let you know how powerful the notary default method, notary certificate of default method really is. It is a very powerful method because the notary is an officer of the court, and most people don't know that. They're sworn in by a judge. They are an officer of the court. So their process actually has weight legally. But most people are having problems because they don't know where to go after they get the notary default. Well, you go to the court to get a judgment. So you file a lawsuit, and you do so asking for a fee waiver. And then you proceed to go to court, and you bring that issue up. Now, I would suggest that you do more research on the notary certificate of default method before you try this method. Do your research first. Make sure you do your research first. That way you don't run into problems later, because anything that comes up, you're prepared for it. Okay, that's the end of this video. We want to thank you for taking the time, for allowing us to show you what the whole issue of, as far as the unrefuted affidavit, stands as truth. And on this page with the unrefuted affidavit standing as truth, I haven't even seen that section again. There it is, unrefuted affidavit standing as truth. There is another section here, rights reserved without prejudice, and no, I'm looking for the affidavit, how to properly fill out an affidavit and what is an affidavit. Give me 1 second to see if I can get that to pop back up. Like I said, you might be able to see the page clearly, but with this video accelerator not being turned off, it's jumbling up the words. Now notice, in order to be valid, an affidavit must satisfy the following 4 criteria. It must state who the person who is doing the affidavit is. It must identify who the notary is. All statements made must be based on personal knowledge, not assumptions. And any statement made that are false are subject to penalties of perjury under the jurisdiction of the court who will try the case. Remember that. Now, it reminds you that affidavits cannot and should not make legal arguments. They should stick to the facts and avoid law as much as possible. When composing an affidavit, make either short positive statements of fact or negative affirmants. Now, here's the thing. You want to be precise. You want the statements to be short, but you don't want it to be to the point to where you're boxed in a corner. So have somebody go over the documents for you. You want to place the burden of proof not on yourself. You don't want to make it to where you have to prove anything. You want to make it to where if they contest what you're saying, they have to prove it. Okay? Now, don't cite authority and incorporate material by reference unless you're prepared, or unless you prepared to reference material yourself, signed it and dated it. Do not make a statement like, I am not a taxpayer. That's an opinion. Instead state that I am not in receipt of any documents which verifies that I am a taxpayer owing taxes to the Treasury Department. You see, that's a fact. Unless you work for the federal government, and you'll have to do the research on this, you're not required to pay taxes within the boundaries and borders of the United States. Only federal employees are required to pay taxes. Go do the research. Type in the information and Google. Do the research. We've done a video where we've taken you to a site. I think it's called constitution.org, but I'm not sure, so don't quote me on it. But it will actually give you the actual revenue laws so that you can read it for yourself and see who's required to and who's not required to pay taxes. I personally have not been required to pay taxes. Even if I was required to pay taxes like most people think they are, I have not paid taxes in over 15 years. But those are because of health reasons for the most part. It's not because I knew that I didn't have to pay taxes. I was just never sure I was required to pay taxes. So, with that information, you do your affidavit. Please follow the examples of other affidavits. Take a look at other affidavits online. So, type in sample legal affidavits. You want the word legal there because you want the kind that are usually produced by the ignorant attorneys, because you want to look at the wording about how most times attorneys will not box their clients into corners. Now, we're talking about the kind that are produced by attorneys. If an attorney has someone do an affidavit, I promise you the affidavit is not in the individual's words. The attorney puts it in his words, and then he goes over it with his client to make sure that his client agrees to what he's put there, and so that they can say that it's in their words. That happens all the time. Well, thank you once again for taking a visit to us here at the Legal Redress Commission, redressright.org, Redress Right YouTube channel. We will be, as stated before, updating the site with the newer information and taking care of the A for V process, so please stay tuned. And thank you and have a very good evening.